thank you, Kini, and everyone for welcoming me. I'm going to do my best to keep it very, light, informal. Hopefully, kind of highlight some of the best planning strategies and keep it. It's a small enough group where, especially, thank you for that background. I'll try to really direct what we talk about for what everybody in our call can have some value from. But certainly, if you have questions beyond what I highlight, again, put it in the chat. I'll break after each kind of section if we have anything, and if not, we'll keep going. And if we save questions till the end or whatever, that's fine too. But I just want everybody to learn something, hopefully, and get some direction for what to do from here. So if that works for everyone, we will move forward. So this first of two-part series that we're going to talk about is really just highlighting some of the most useful tools in our tool belt when we're talking about specifically preserving money and assets, but also the care of our loved ones, particularly who may have needs that go beyond what your typical 18-year-old or 34-year-old or 21-year-old would have, and might have resources available that someone else might not. And how do we get the best benefits for that? So just a little bit more about myself. I'm licensed in Missouri and Illinois. I'm going to focus on Missouri. I didn't hear that anyone is outside of Missouri, but if no, okay. So we'll focus on Missouri, Illinois. Again, if you are from Illinois or have questions, sometimes at these not-for-profit calls, we have people from all over the country, and I always have to preface everything coming from anywhere else. I'm not licensed there. I'm not sure of the rules, but here's what I think would happen. So I'm glad we're just going to stick with Missouri today. I went to SLU, then I went to Mizzou, got my MBA, my law degree. I have a Series 65 financial license, insurance license. So I kind of look at everything from the full scope of everything, not just how to qualify for government benefits, or not just should I sell a trust to this person or not. That it's really all about looking at the best results for every individual case, using all the arrows in our quiver. And that's why we're going to look at a few of them today. I am part of the National Academy of Elder Law Attorneys, who we do a lot of advocating for both seniors and those individuals with developmental disabilities or special needs. And I'm the president-elect now, so starting next year in January, I'll be the president. We have about 150 attorneys across Missouri who specialize in those areas. And then the American Academy of Estate Planning, which a lot of this involves estate planning as well. And across the country, we have hundreds of law firms. I'm not sure of the exact number, and I'm on the board of governors for that as well. So I'm really tied in, I think, on the front lines of some of the issues that we're going to talk about today. So just to kind of talk about what our firm's mission is we want to help families secure their legacy. And I say the word legacy, and I know for some people that's charged like, oh, these must only work with people with millions of dollars. And that's not what a legacy really is. A legacy is taking care of those people and causes that you care about, and living beyond just how to get your stuff to the next people that you leave behind. And the only way to really do that, I think we've found, is to embrace each client through a long-term personal advisory relationship. And the reason I want to say this is sometimes we can't just flip a switch. I think one of the members on the call today said something about having a trust in place for 20 years ago, and it kind of seems like maybe it's not up to date. And I can tell you, I've been doing this for over 12 years now in this area of law, and I can tell you 12 years ago, most recommendations were, put it together, and then maybe after 3 years, take another look at it and see if there's anything that needs to be updated or if any laws changed. But otherwise, you're probably okay. I can tell you, to do this really well and to make sure you're getting the best benefit, we like to look at it every single year. What's changed in your life? How has health changed for yourself, for your loved ones? How has your wealth changed one way or the other? How have laws changed one way or the other? And if nothing needs to change, then great, we're good. And if something does, then we're on the front lines of it. So just realize this is going to be a moving target, for any family, and for all of our clients. We want to have that long-term advisor relationship, kind of like you might have with a financial advisor or your accountant that we're all seeing this time of year. It's a good idea to have a person like this on your team too. So again, this is myself. Jackie Capriano in the middle there is our attorney that does a lot of the initial meetings with clients. She is just such a great, loving person, and mother of three. Just like you'll see that I'm a father of three, but she does such a great job of just meeting clients, figuring out what are the things that might help this family or not, and then go from there. And then Charlie Amon is our senior partner. He is knee deep in tax returns right now. He stays till about at least 8 or 9 o'clock every night, and we'll be doing that apparently until the middle of May now, because tax time has been extended for another month. So I just wanted to kind of introduce you to some of the other faces before I get going. Is why are we doing any of this? Um, some people come to me and say, Paul, I just want to avoid all my money going to the government when I die. Some people say I want to avoid death taxes and estate taxes. And then when I ask them, well, do you have over $11.5 million? And they said, no. I said, well, then you're doing it. What's next? You're not paying estate or death tax right now. Now, I will preface that again with laws change. We have a new president, we have a blue Senate, blue Congress, blue president, which means it's possible that taxes could be raised and or exemptions could be lowered. But for now, estate taxes and death taxes and avoiding probate. There's lots of ways that you can avoid probate. And I know we'll talk a little bit more about all of this in next week's installment, but the reality is the reason you're doing it, and the reason that I do it in most cases, and the reason most of our clients do it, is because if I didn't come home from work today, I care about these people on the screen in my case, and you're all here because you have people that you care about, or issues and causes that you care about, that if you just didn't come home one day, you would want to be sure that they're well taken care of. And while you're alive, you want to make sure you're making the best decisions for them on a daily basis. And so my 2-year-old there is Lewis. I got Olivia just turned 5 in the middle, and then Audrey is 6 years old, and then my wife Sally's in the picture on the right too. But everything that I do is for the people that I love and care about, and I'm sure you're doing that too. So just recognize that as the reality of why you're doing any of this planning, or any planning that you've done to this point is for the people and causes you care about. Yes, I think you're muted.
Sorry, I just wanted to say before you went on, I wanted to introduce Pat. She said that her son Michael is 35 years old. They have a special needs trust, and they are his legal guardian. So thank you,
Perfect.
Pat, for filling us in on that. I appreciate it.
Great. So some of this stuff that I'll be talking about, it sounds like you guys are familiar. At least some of you are familiar about some aspects of them. Some of you might be familiar with all of them, but might have questions about, is there something new, different? What do I do in the case of X? So I'm going to introduce, and I want to talk about each one, and then we'll have questions if at the end, where if you say, hey, I have an ABLE account, but X, and I didn't talk about that, and then we'll talk about it then, or we can talk about it at the end if you didn't get your question out. But this ABLE Act is actually a relatively new tool in the tool belt for all of us, and it was first introduced in 2007. And it was called at the time the Financial Security Accounts for Individuals with Disabilities Act. So ABLE Act has a little bit nicer ring to it, I think, and helps us keep track of it. It was reintroduced in 2014 and was finally passed in the House in December of 2014, and the Senate a couple weeks after that. and signed into law at the end of 2014 as the Achieving a Better Life Experience Act of 2014. So really, this is something that's been around for less than 7 years. But it is another tool in our tool belt, and we're going to talk about what are some advantages and disadvantages. But Missouri got it into law about a year later in October of 2015. I did this presentation or a presentation with this information, with some of this information for St. Louis ARC. I think maybe it was 2 years ago, and there were 21 states at that point that were that allowed ABLE Acts, and we're now up to 43 already. So Missouri and Illinois are both states that'll have ABLE Act accounts, and so we're good. What is it at a glance? So it's not a silver bullet that parents and loved ones can use in all cases, and it doesn't help with costs. It's a place you can put some money to help with what we'll call qualifying expenses, but it's not like some programs like SSI or Medicaid where you have resources and other things available to you. It's really just a place that we can have. It's really, when it was introduced, it was kind of sold as, if you don't want to go through the expense and the complicated nature of a special needs trust or supplemental needs trust, then an ABLE Act account might be for you. And I'm going to talk about some of the things that it will do and some that it won't. But it is a good weapon to have. And I'll say this. For people that would otherwise be setting up a first party special needs trust with under $100,000, this would be a great tool. Otherwise, I'm not sure it's going to be the best answer. And I'll talk about special needs trust in a second about what that necessarily means. But I guess I'll say at this point, a first party trust is a trust that is funded with the assets of the person that's the beneficiary. So in the cases of special needs trusts, a lot of times it is somebody inherited money and they're on government benefits, or, and again, a lot of times it's Social Security, like SSI or Medicaid for health insurance benefits. And having that money would disqualify them for the benefit. So that person would create this first party special needs trust to take it off the table. A third party special needs trust or a third party trust would be a trust that's funded with assets from someone other than the beneficiary that we're naming. And that becomes an important differentiation when it comes to things like a payback provision. And so ABLE Act accounts are a great place to put resources that were either earned by an individual that's on government benefits that we're afraid that we're going to lose them, or it was too late to create some sort of third party device and it's now become the person, the loved one who's inherited the money has already become their money, and we don't want to lose benefits, and we want to put it somewhere that's kind of less intrusive. So ABLE Act at account, or ABLE Act at a glance. So not all individuals with disabilities would be qualified to open an account. It's only if the disability occurred prior to attaining age 26. And that means the disability needs to have been established before age 26. It does not mean that the account itself had to be established before age 26. So if your loved one is 34 or 35 and you've never set one up, it doesn't mean that you couldn't set up an ABLE Act account. It has to be for individuals living in a state that's authorized ABLE Acts, which again, anybody that I'm working with, that would be the case. Only one account can exist per individual. So sometimes it's like, well, can grandparents set up one and parents set up another, or one parent set up one and another parent set up another? There's only going to be able to be one ABLE Act account per individual. Total annual contributions can't exceed $15,000 in any 1 year from any one individual. But you could put as much as $462,000. Now, I will say most government benefits, if it's over 100,000, it's not going to be an exempt asset anymore. So you got to be careful about doing that. But upon death of an ABLE Act participant, any dollars remaining in the account would have to be paid back to the state Medicaid after paying other outstanding expenses and funeral expenses. So this goes back to that first party versus third party. This is a payback provision, and a first party special needs trust also has to include this payback provision that to the extent any government benefits have been received, any money left in this trust or in this ABLE Act account would have to go to repay the benefits before it could go to anybody else. And so it's not a great way to avoid all payback provisions if you've got other options. And again, SSI, for instance, would be suspended if it got over 100,000. So just because the account's allowed to have more than that, you want to be very careful if you're receiving SSI or any other benefits. The ABLE Act account contributions in Missouri are just like, they're built off the same code that 529s are. So 529s can be used for qualified education expenses, and that in 2017 was extended to include K through 12 in addition to college expenses, or K through 12 in addition to college expenses. But you can only deduct up to $8,000 of contributions if you're single, or $16,000 of contributions if you're married filing jointly. And just like a 529, any amounts in the account would grow federal and state tax-free and would remain tax-free as long as used for what's called qualified disability expenses. And there's a penalty if it, just like in a 529, there would be a 10% penalty plus any taxes on the earnings would be due if the account was used for anything other than a qualified disability expense. You can roll over a traditional 529 that's meant only for qualified educational expenses to this ABLE or stable accounts, as they call them in some places, without a tax or penalty, where it can then be used for any qualified disability expenses, which, as we'll see, are a much wider array of expenses that you can use without penalty if you would qualify for an ABLE Act account. So what is a qualified expense? If you incurred the expense at a time when you were considered an eligible individual, and the expense relates to that disability, and the expense helps you maintain or improve your health, independence, or quality of life, then it would be a qualified expense. Now, that doesn't seem like it'd be that helpful in most clients that I work with when it's anything about, hey, I'm on SSI, can I use this money for this? Or can I use this money for that? Or this is coming from an SNT. What does that really mean that I can use it for that won't affect these benefits? They want examples. So here's a list of examples that would be a great place to use ABLE Act account monies. Tuition is still eligible just like any other 529, but in addition to that, you could use expenses for a primary residence or rent, mortgage payments, real estate, any kind of housing expenses. Note that if you're using ABLE Act funds and you're receiving SSI, those two things can affect each other. So just like coming from a special needs trust, just because the special needs trust allows some of this stuff to be used for housing, if SSI is involved, you want to be very, very careful about supplementing, but not supplanting, impairing, or diminishing any forms of government or private support that is otherwise available. Transportation expenses are allowable. Employment support, health prevention, wellness, including premiums for health insurance, medical, dental, vision, therapy expenses, long-term care, support services, adaptive equipment, personal assistance, all of that would qualify as a qualified expense. Again, assistive technology, and then miscellaneous things that are listed on there, legal expenses. That's a personal favorite of mine. No. We have another lawyer on the call, so I can get away with saying that now. No, financial management, home improvement, funeral, burial expenses are all allowed. So It is an investment account. It's not a bank account. So one thing that I encourage people to learn about is how it's being invested and choose an appropriate option. Um, are these funds that you expect to use in the next 1 year, the next 5 years, the next 10 years, 20 years? Are you going to be contributing new money to it, or is it all just, hey, this is one big chunk, we're just going to leave there for a while? Because if that's the case, the longer your time horizon, the more aggressive, the more you'll want to invest it probably in some form of equities or stocks in addition to just sitting in a bank account, because you're doing yourself a disservice over most 10-year periods if you're not invested in stocks and equities, and if it's just sitting in a bank account. And particularly the last 10 or 15 years that we've gone through, where bank accounts have paid essentially 0% and the stock market has kind of blown up. That's not going to happen every year, but again, using that growth from historical growth versus historical risk, you should find an appropriate asset mix. And they do have very low costs, administrative fees and management fees. So that's always one part of the equation. And you can have basically like a check issued, or you could have direct payments from the account to whatever your utilities or whatever you decide to cover. And you actually also could get almost like a debit card to use on that account as well. Who would have signing authority? Under the regulations, the designated beneficiary, who is the qualified individual with a disability, is the account owner. And if they are able to exercise signing authority, then they would be in that position to be the signer. Otherwise, you would have a designated agent, or a parent or legal guardian could have authorized authority over the account if the qualified individual does not have the ability to sign. And a lot of people don't understand that if a loved one or anybody has a qualified individual with a disability, that doesn't mean they don't have the ability or understanding to sign a particular document or to execute a particular arrangement. Legal capacity, once you're 18, is presumed. Now, as we're going to get into with guardianships, that presumption is taken away when a legal guardianship is instituted and the court has ordered that. But without a legal guardianship, it's presumed. So it could be that the individual has capacity to do X, but not Y. And so one of the things that we'll talk about is whether a power of attorney makes sense or not, and where we are with that. And so with that, the same exists with these ABLE Act accounts. And again, my general feeling on ABLE accounts is it's a good rule. And again, it's great that we have signing authority and can have the ability for a legal guardian to be the signer on the account, but it's not your perfect answer to all questions. So with that, that's my first kind of break. Any questions on the ABLE Act accounts?
So we've got a question. It says, can you open an ABLE account at most financial institutions, or does each state only sponsor ABLE accounts at particular institutions similar to 529 plans?
Yeah, it's exactly similar to a 529 plan. So Missouri has a designated, the way that I've at least gone through it so far is just like Missouri. There are 529s you could get at Edward Jones, or Morgan Stanley now does it. There are a few other places, but if you put in, Missouri ABLE account in Google, it just sends you to moable.com, and they can talk about where can you set it up, what options do you have, and I would go that route. I've not seen a bank or had examples of a bank that handles them directly. And again, maybe some of you that have ABLE accounts have had a different experience, but I've always gone through moable.
So, Paul, let me ask you this question for the benefit of those that are here that have younger children.
Mm-hmm.
What is the age limit to open an ABLE account?
You can open an ABLE account for a child of any age or an adult of any age, as long as the disability started before they turn 60 or 26. But again, obviously a 2-year-old wouldn't be a signer or whatever
Right.
on their own accounts, but you could certainly set up the ABLE account for a qualified beneficiary that's age 2, or I, maybe even, I've not seen it, but maybe even before birth. I don't know if you can establish the disability, um, but I would say maybe not before birth. But
I wonder because if you get a pre-birth diagnosis,
right,
that
yeah, I haven't pushed that. I mean, I guess you don't have any social security number or anything to attach to, but yeah,
nice. All right. Thank you.
I thought, yeah. Okay, so I'll move on from that then, and so we can keep moving along. So special needs trust, and the first thing that I always say, because I get this question because this is all I do is estate planning and this type of stuff, and people say, "Hey, do I need a trust?" I have no idea. You know, a trust is not a trust is not a trust. Or, "Hey, I'm the trustee of my dad's trust. Can I do X?" Don't know. You know, each trust is going to state in those pages what you're allowed to do and not allowed to do, whether it works for A or B. When people say, how much money do I need to have before a trust makes sense? You need to have enough money to justify the fact that it's going to cost you money to set it up. And depending on the type of trust, might have an extra tax return you got to file every year. If you have enough money that the benefit that you're going to get from that trust outweighs that expense, then you've got enough money. So, you know, if avoiding probate's your only goal, again, there are other ways we could do that, but a lot of times people want to protect the money for those people and causes we care about. And so a trust allows us the most options in the most ways to do that. And so the first party trust I've already kind of alluded to. Um, for it to be established, we would have to ensure that the beneficiary is under 65 when the trust is established. And I come across this more often when working with families who maybe mom or dad have dementia and they're going into a nursing home and we're trying to protect some of their assets. They say, well, can we use a special needs trust? Well, we can't if mom or dad are 80 now. A first party trust would have to have been established prior to 65. You know, oftentimes, I guess we could do a revocable first party trust, but oftentimes they are irrevocable if we're removing them from the estates of the individual that has created the first party trust. And I used that language earlier that any assets in the trust are supposed to supplement, but not supplant, impair, or diminish any forms of government benefits. The trustee is the one that's really given that discretion about, can I use it for this? Can I use it for that? Because the only direction the trust really says is don't get me kicked off benefits, and that's it. And it does have a spendthrift provision, which means if the individual beneficiary was sued or had creditor problems or something like that, any of the assets in the trust would be protected, which is good. Third party trust, as I mentioned, is funded with somebody else's assets. So if you are a parent of a child with disabilities or special needs that we're looking for government benefits potentially, or we don't want to get kicked off of any benefits, or we want to put somebody else in charge, you are better off. I think of a trust like a tube of toothpaste, and you're better off keeping it in the tube of toothpaste that you've created for yourself or yourself and your spouse, and leaving it for the benefit of the individual or people that you care about without squeezing the tube of toothpaste out. Because once you squeeze the tube of toothpaste out, you squeeze the toothpaste onto the toothbrush, it's out. And we can't protect it the same way we could if we kept it in that trust or in that vehicle while you and your spouse or whoever's money it is still alive. And we keep it from ever becoming the person with disabilities money, and it doesn't ever affect their life. We don't have to worry about payback provisions and other things. So same standard, can use it for all the same benefit, supplement but not supplant. You can put a third party trustee in charge, have a spendthrift provision, but the key is there will not be a payback provision. So no matter how many years the person was on SSI or the person was on Medicaid or any of those things, and no matter how much money is in the trust, you could say, and I want to leave this for my daughter, Audrey, with special needs in a special needs trust, third party special needs trust, make sure she keeps getting benefits. If she would pass away, then I want the rest of the benefits to go to my other two children, Olivia and Lewis. And there will be no payback, and I can do that. That's perfectly acceptable. So it's a great tool to use. And again, anybody that has somebody that they care about that they don't want to just dump all the money out to them, is a good idea to set up your own trust. And then that way you can direct for each person you care about, how is the money going to come out? What are we worried about? What are we trying to preserve? And how do we want it to go if that person predeceases? So let's compare an ABLE Act account to a third party SNT. An SNT can be set up for any person with a disability. There's no age restrictions, whereas the ABLE account, if you're going to set it up, the disability must have been established before age 26. Who can fund that? Again, a third-party SNT, anybody can fund. A first-party SNT, even the person with a disability could fund that special needs trust. An ABLE Act account, anybody can fund it, but again, there will be a payback provision. So you're better off not creating something with a payback provision if we have an option to create something that won't have a payback provision if you're getting any benefits to start with. How many ABLE accounts can someone have? One. How many SNTs could someone have? As many as people are willing to fund. So grandma could have a third-party SNT set up for their grandchild that they care about, and mom and dad could set up a third-party SNT. Their neighbors could set up an SNT. There's no rules or restrictions against that. Who can control the account? Again, in an ABLE Act account, the person with a disability could be in charge, but likely it's the legal guardian. I know many of you already have a guardianship or conservatorship, or an agent if we have the ability to get a power of attorney signed. A third-party SNT, the individual receiving benefits or potentially receiving benefits cannot be the trustee and maintain that asset protection. So you're always going to need to have a third party in charge. It doesn't mean you have to have a bank in charge or a lawyer in charge. It could be your brother or sister, or the brother or your another child, or whatever you would want to have in charge. That works. How much can you fund in a year? Again, you could leave $1 million at your death to fund an SNT, or during your lifetime. An ABLE Act account will stay at $15,000 or whatever the annual gift exclusion amount is for that year, which is still $15,000 right now. And is there a payback provision? Third party SNT, no. First party SNT, ABLE Act account, yes. Is there a cap on how much can be in the ABLE Act account? Again, 100,000 is the limitation if we're receiving SSI. If we're not, then it can go up to 462 right now. The third party SNT has no limitation. Here's a big advantage though on the ABLE Act account. If used for qualified expenses, there is no tax. So if you put in $50,000 and the $50,000 gets growth through the market, whatever investments approach you have, and 10 years later it's worth 100,000 and you use 20,000 of it, each year you're not filing a tax return because there's no taxable income. When you make the distributions, there's no tax to file. If you set up a special needs trust or a supplemental needs trust, oftentimes it'll have its own separate tax ID number so that we can, again, protect a beneficiary from getting kicked off of any government benefits. So that means that separate tax ID number will file a separate tax return. And again, depending on what money's in there and what income's happening, there could be taxes due on that money that's earned. So again, the right answer for you and your family depends on a lot of factors, but I want everybody to understand what types of distributions can be made. Only qualified disability expenses as defined by the government, which I kind of laid out for you today. A third-party SNT basically says, just don't get me kicked off any benefits and you can pay for it. So that's kind of a quick rundown on trust, supplemental needs or special needs trust. And again, you can't be experts in 10 minutes per subject or 15 minutes per subject, but I want everybody to understand the structures and the pluses and minuses. So any questions, Nikini, on that or thoughts?
Yes, so there is from Ms. Christine, if someone else controls the third party special needs trust, for example, a sibling, if they go through a divorce, will their spouse have access to that?
No, great question. Actually, the trustee's personal life is not affected at all because they're not a beneficiary. They are a fiduciary for the benefit of someone else, so it's not their money. So they could get sued. They could run up a bunch of credit card debt, and Discover Card could come after them, or they could go through a divorce. They could get in a car accident. None of that stuff matters because this asset that they are the trustee of, they are not a beneficiary of. Now, even the person who is the beneficiary of the trust could have all of those same things happen to them, and it wouldn't affect that money because it's got a spendthrift provision and it is not available to them for any reason. It is not available to them for a divorce or for anything or for Discover Card. It is only available to them to the extent it is used to supplement but not supplant, impair, or diminish. So I actually have we're a corporate trustee for a beneficiary who's got an S&T share, and the beneficiary is going through divorce, and of course spouse wants half the money from the trust, and so we're able to protect 100% of the benefits for the beneficiary of that S&T. Has nothing, not involved in the divorce. So good question though.
Ms. Jerry, you had a question?
I sure do. Paul, our
Mhm.
situation is that I'm not a fan of ABLE accounts because of the payback provision, as well as the special needs trust, which we are recently researching and figuring that out. If I'm understanding you correctly, there's an ABLE account, there's a special needs trust, and there's a third party trust, which has no payback provision. And the trustee has total discretion, and it includes a spendthrift provision. If that's true, what's the catch? Because this is kind of what we're looking for, but there's usually always a catch.
Right. Yeah. The only catch is that the money can't have come from the person for whom you are getting benefits. So because it's a third party trust. So if you're talking about, hey, we want to fund money to care about our child, to take care of our child, and we want to start putting money there. So with a lot of my clients, I talk about, well, how is Adam? Is it Adam, right?
Adam,
Yeah. How is he getting things paid for right now? And I don't need you to disclose for in front of everybody, but let's just say it's, well, he gets SSI and he lives on that, but then of course we pay for everything, mom and dad or whoever it may be. And I would say, is there any reason why that couldn't keep happening for as long as you're alive, the two of you are alive? And is there any reason that you need to set aside money right now during your lifetime for Adam or not? Because one thing, the easiest thing to do is just keep paying for it. When things need to get done, have mom and dad just pay for it. Now you need to have your own plan that says, well, what happens if you get bopped on the head, or what happens if you go into a nursing home and there's no, we want to make sure there's a plan to make sure there's always money to take care of our son. And the third party S&T that I do most frequently is just built into your estate plan. Your trust would just say, at my death, maybe you want 100% of whatever you have to go to a trust for the benefit of Adam, and write that trust as a third party supplemental needs trust. We would get a separate trustee and a separate tax ID number. And again, it would have to file a tax return every year going forward. And generally, third party trusts pay taxes any trust, if it gets taxed internally, will pay taxes at a higher rate faster than an individual would. So we got to do all those factors. But so the path of least resistance is often have a plan for what would happen if you couldn't just keep paying the bills the way you always have. But setting up this first separate standalone first party S&T that you might have set up 20 years ago funding it with assets from your bank account or your husband's or your investment for the benefit of your son definitely is putting money at risk for a payback that doesn't need to be at risk because there are other ways you could pay for it. Is that
We put in Adam. We bought him a house. He has
Mhm.
Downs. He has people that support him in the home. Uh,
Mhm.
House. We want to stay with Adam if something should happen to us, and so we're putting assets in there. Is that also something to be that could be having a payback provision when Adam dies? Would his house be something that they would have to sell and pay back as well?
Yeah, so again, it depends on what benefits he's on and whether the trust is a first party trust. So it shouldn't be a first party trust in the sense that you are funding it with your assets. They're not Adam's assets. The house, you're paying for it. So it should be a third party trust, in which case it shouldn't have a payback provision because it didn't need one. But once it becomes his asset, because either the trust is written as a first party S&T or whatever, then anything in there is subject to the payback provision. And now you might say, well, isn't a house exempt for Medicaid purposes? Well, it's exempt for qualifying for Medicaid, but the estate recovery can still collect on the value of the house of the participant from Mo Health Net, even if they claimed it on the application and said, yeah, I got a house, but it's exempt, so no big deal, right? Well, it's no big deal while you're there and living in it, but when you pass away, Mo Health Net will file a lien and collect against the house. So um, I would have the trust reviewed to make sure it's what it's supposed to be. B, is there anything you can do about it now or not? Like, could it be changed? Could it be gifted back to you guys and you set it up in a different way?
Right.
What makes the most sense? Because it's all about asset protection for sure. And then let's say you or your husband needed long-term care and you needed Medicaid in the future, and you say, well, I don't want all my money going to a nursing home, and then there's no money available to take care of Adam. There's a specific exemption to gift penalties for giving to a disabled child of any age. So you could, at that point, create a standalone third-party supplemental needs trust or special needs trust, gift all of your assets into that for the benefit of Adam with somebody else as trustee, and you could
Okay.
go on Medicaid tomorrow in a nursing home without a transfer penalty. So it's all about having a plan of what if this happens, and then making the right choice based on life as we know it now,
Yeah. Tell us about that, Paul. Yes. That's our life.
Yeah.
Thank you. That
Yeah,
has
sure.
opened up a lot of stuff for us.
Sure.
So a couple of more questions for Miss Christine. So if the individual has a job, for that money to not affect benefits, can it be set up to go into an ABLE account?
Yeah,
Then
oh, sorry, go ahead.
then she said, then a third party special needs trust can be set up for us to help support her. Question.
Yeah,
So
perfect.
essentially, they will have ABLE, special needs trust, and SSI.
Right. Yeah, that would probably be the ideal way to do it. Is ABLE accounts are great for, hey, I'm over $2,000 and I need SSI, or I'm over $5,000. Because the individual that's receiving those benefits themselves bank account is getting too high, but they don't have $100,000. They don't have $500,000. So maybe setting up a first party trust and all the extra paperwork that means and the expense up front of drafting that might not make sense for that. But monies from gifts, from like I said, parents and grandparents typically, but anybody, you're better off not making that a first party situation. Never let the person that's receiving the benefits actually have that money into their name or in their account. Then we avoid the payback provision. So using a combination of those things, depending on the source of the money, is the best strategy for sure.
All right. Thank you. And the last one is from Ms. Pat. If you would put $50,000 in a third party special needs trust, would that be a problem with the right to give 150,000 to a person as a gift?
I think they're probably referring to the 15,000 annual.
50,000, yeah. Sorry, my eyeballs.
No, that's all right. So I think the question is, let's just say my wife and I want to establish a third-party special needs trust for one of our children. And generally, when you make gifts to anybody, anybody else, including a child or of yours or anything else, you're limited to a $15,000 amount before you're supposed to tell the IRS about it. It's called your annual exclusion amount. Now, I will tell you that in most people's case, it's who cares if you have to tell the IRS about it. It means filing a Form 709. You still wouldn't owe any taxes unless you gave more than the lifetime gift amount, which right now is $11.5 million. So most people don't give away more than $11.5 million. So if I gave 50,000 in 1 year, I'm supposed to tell the IRS, hey, take this away from my lifetime exemption amount of $11.5 million. And they say, oh, okay, well, that'll never happen. But because that annual exclusion amount and that gifting, this little bit of the estate tax exemption amount used to be 600,000 in the 90s, and it was $1 million in the early 2000s and made its way up to 3.5 million, and only recently jumped up to 11.5. So there were a lot more people that had to worry about the lifetime gifting that don't have to right now. And again, as I said at the beginning, that could change. Maybe Biden and Harris will say we're going back to $1 million, and it might really affect you. So always be cognizant of that number. But to answer your question, each husband and wife can give 15,000 per year to each child or each recipient. So if you're married, make it 30,000, and then in January do another 30,000, and then you don't even have to address that issue if you're worried you might one day pay gift tax.
Okay.
So,
All right. Thank you.
so that was probably more than you wanted to know, but I do my best to.
It's okay.
All right, so going on to guardianships, and again, I'm going to kind of hit high level because A, I already know it's 7 o'clock, and B, it sounds like a couple of you have been through this process already. One thing that I do like to say is sometimes it's not the greatest option, but it's supposed to be the option of last resort, and in many cases, it's a lifesaver when you do it. But people are surprised that the process is so hard. They're like, this is my kid. I've been taking care of my kid from the time they were born or before they were born until the moment they turned 18. And now all of a sudden people are asking me if I have guardianship. What do you mean? They're my kid. Of course I have guardianship, and they don't know that it's a separate process. Now, guardianship and conservatorship. I've had a lot of questions that people ask me. I just did a guardianship for someone whose child had just turned 18, and she needed to become legal guardian. And she was surprised when the order came and it said, you're the guardian, but it said, we are not issuing at this point a conservatorship. You are a full guardian, and you're not the conservator. We're not appointing a conservatorship. In Missouri, the guardianship is the person who can make decisions regarding healthcare, placement, day-to-day life decisions on the physical well-being of the person who's being cared for, the respondent. The conservator is in charge of any money that person might receive. Now, if we don't need a conservatorship, that's better, because the court requires a lot more bonding, a lot more filings if you have a conservatorship, because they want to know anytime you need to buy new socks and underwear for the respondent, you have to report to the court and get a court order, and they make you set up a restricted account and all these things. And she said, well, how am I going to open a bank account for my SSI that we're getting for my daughter? And I said, well, SSI, Social Security has a separate process called becoming the rep payee. And Social Security doesn't care if you're the legal guardian or not. They don't care if if you have a power of attorney or not, which we see a lot of times as older adults get dementia or something like that. They have their own process to become rep payee. And if you're rep payee, that SSI check can go to a rep payee account and not have to be reported to the court under a conservatorship. So the only time we'd have to get a conservatorship is if somebody gives your child money or gives, we have assets that are outside of SSI that we need somebody in charge of. So I want to make that point, because you could have full control as a guardian and not have a conservator if that individual doesn't have any assets of their own outside of SSI. But it does put the court in control. It does take time. I have people that, want to file it on the 18th birthday and have a court issue the order that day. That's not going to happen. I mean, we ask for emergency hearings all the time. We might get a hearing quicker, but they're still going to put it out for full guardianship. It usually takes a couple months. All the personal information is disclosed, costs thousands of dollars. I mean, even kind of an uncontested, quick and easy thing will usually cost a few $1,000s in court fees, attorney's fees, accounting fees. And again, if you have conservatorship and other things going on, there could be more fees down the road. I will tell you some recent developments if it's been a while since you've gone through this process, or if you haven't gone through and you're wondering if you have. They've added some language. Historically, the respondent in a guardianship hearing has been called a ward or a proposed ward, which kind of sounds dehumanizing in a lot of respects. So proposed incapacitated, disabled, or respondent has been replaced throughout the code. Least restrictive alternative is always what we're looking for in terms of housing arrangements. And it's the greatest possible inclusion of the person into his or her community as appropriate, considering physical and mental condition and financial means. And when they say the person lacks capacity, we mean lacks capacity even with appropriate services and assistive technology now. Another couple of changes is the priority of listed guardian. Obviously, a lot of times when we set up a will for our minor children, we list the legal guardian as part of your process in your will. And you can still list that, and that legal guardian recommendation could also be if you are the legal guardian of an adult with legal guardianship. That'd be one way to do it too. But if the incapacitated or disabled person is able to communicate a reasonable choice, then any person so reasonably nominated. There used to be something in the guardianship code that says if your power of attorney is older than 5 years old, then the agent named in your power of attorney no longer has priority, because they said that an agent listed in your power of attorney executed no longer than 5 years ago would be the first person in line to be guardian if you needed a guardian, but does definitely prioritizes family over a third party. There is a background check and credit history that's done at the expense of the petitioner, but that does not apply to the spouse, parents, or children who are at least 18 or siblings. So there are some people that kind of waive that requirement. Least restrictive alternative, again, respondents' needs may be met without the necessity of the appointment of a guardian or conservator. They have to consider that before they appoint a legal guardian and conservator. Is there anything else that's available that would work? Like, could this individual sign a power of attorney and name an agent that would give them access to the bank account? If so, then a guardianship's not appropriate. But again, these are other things that they consider. Is there a power of attorney already in existence? Is there a rep payee for public benefits and therefore we don't need a conservator? Is there a trust where a trustee's in charge and that's the only place there's an asset? Well, then we don't need a conservator. And so are there other things that are available to help? As I mentioned, the emergency appointments cannot exceed 90 days. It used to be 30 days. So they've extended that. We could get a temporary emergency appointment for up to 90 days, but then the hearing's got to be held sometime within there. The petition for guardian conservator would terminate after that 90 days until a full hearing can happen. So again, and it also needs to be very specific if you want your child or the respondent to retain the right to marry, or to retain the right to vote, or to retain the right to drive. A full guardianship wouldn't allow any of those things. Now on the petition, they'll actually ask those questions. Are we trying to retain specific carve-outs or not? We need clear and convincing evidence, not only that an incapacity exists, but that there also needs to be clear and convincing evidence that a less restrictive alternative would not meet the respondent's needs. And if a less restrictive alternative doesn't exist, they'll also say, well, what about a limited guardian only for this purpose, or a limited conservator only for this purpose? And so all of those things would be included on the annual reports. Again, for those that already filed this, you probably know, but for those that don't, you want to include, and they will ask, plans for future care, summary of the guardian's visits or activities, or if the person lives with you, extent to which the respondent participated in any decision making, any changes in conditions since last report, and then a summarized plan for the coming year. So guardianship report only needs to be filed once a year. You'll get a notice about that. And then if you do get to the point where restoration is appropriate, then you could file that with the court when and if that's appropriate.
The one question was, is guardianship in Missouri good if you move to another state?
Yeah, great question. So the states have it's called the full faith and credit of the Constitution clause. That does not mean that means that states have to respect the jurisdiction of other states and their decisions. But when you move states, then Missouri no longer has authority over you. So you should transfer the guardianship to whatever state and county that you move to, and you can usually do a transfer as opposed to have a full hearing and another finding. So that's the route you do. And I've moved them from Illinois to Missouri and vice versa, but it doesn't require starting over or anything.
All right, thank you. Yeah, just knock it on out.
All right, so powers of attorney for healthcare and property. I just make this point to everybody because a lot of times it's the parents and loved ones that are here for another reason that are guilty of not even having the base level of documents for themselves. If we've seen anything in the last year, it's how quickly someone could go from very healthy to on a ventilator and unresponsive and unable to do things. And if you can't make the decisions yourself for anything that you have legal and financial authority to do, you want somebody to be able to do that for you. So sometimes the worst thing that can happen to you isn't dying, it's getting bopped on the head and living, or being put on a ventilator and having nobody that can make those decisions. And I have doctors that tell me that'll say, oh, well, I literally had one, he was a younger doctor, but still, he said, I'm not married, I have no kids, so I wouldn't need to do like a healthcare power of attorney or whatever. And I'm like, explain to me your thought process. You might be the person that needs to do it, because first of all, not even a spouse or adult children or parents the second you turned 18 have authority to make financial or legal decisions or healthcare decisions for you. Missouri does not have a default healthcare surrogate list. Illinois does. So if you don't have a healthcare power of attorney in Illinois, your spouse would have that authority. Or if they couldn't do it, you didn't have a spouse or adult children. Missouri doesn't have that list. So your spouse does not have the authority to pull your plug, does not have the authority to say give them the surgery or don't, does not have the authority to say give that pill or that pill. Your spouse does not have the authority to sign on behalf of your IRA just because they're your spouse. You need to grant that authority. And the only way to do that is short of a guardianship or conservatorship over the person is a power of attorney. Now, a guardianship, as I mentioned, you're basically filing a lawsuit to take away that person's rights and put you in charge of making all decisions, like putting that person back in the position of being a minor under the parent's guard. A power of attorney does not take any rights away from the person that grants that power of attorney. So I, as the principal, can authorize my wife to make decisions for me. It doesn't take any decision-making authority away from me. She would either be immediately able to do that or only able to do it after I can't do it myself. But again, everyone over 18 should have one, because there is no one, if you live in Missouri, there is no one that can do it without this. And you need to decide who would make those decisions if you can't do it. So decisions that we ask, should it be immediate as soon as you sign it or springing? I almost always do financial powers of attorney as soon as you sign it. So my wife right now, while I'm doing this presentation, could walk to the bank and access a bank account that's in my name and not in her name with a power of attorney. And she doesn't have to prove that I couldn't do it myself. She doesn't have to prove that anything else is existing. She's my agent under power of attorney. Medical decisions have to be springing. So my wife could not go to the doctor if I said, hey, I don't want a surgery, just give me the pills, I want to try that first. My wife couldn't go in there and say, nope, I'm the power of attorney agent, or I'm the agent under his power of attorney, give him the surgery. My vote's the only one that counts until the doctors have determined that I lack the ability to make or communicate my own decisions, at which point she would have that authority. Durable means that it survives any disability. Limited could mean I could give someone the power of attorney to enter my safe deposit box every other Tuesday if it's sunny and over 70 degrees, and that's the only power they could have. Or I could say you can do anything and everything that I could do, and there's still some things that wouldn't be included unless it's specifically limited. So capacity required. Again, disabilities can exist, and we could still sign a power of attorney if that person has the ability to understand the contents of what they're signing and the effect of what they're signing. So again, that's a judgment decision that we would have to make on any given individual. So again, sometimes people say, well, dad got diagnosed with dementia, so I don't know if he can sign a power of attorney. You could have a diagnosis of dementia and fully understand what we're saying while we're saying it, and then forget in 5 days that we had the conversation. And as long as you understand at the time you're signing what you're signing, then you could sign that. So people always ask me, and I like to wrap up with, what do we do? How much do things cost? How do we figure out what's going on? So I always say, no matter who you work with, whether it's the people you started with 20 years ago or somebody you Googled or somebody you heard speak one time, only work with somebody that listens to you and asks good questions. Feel comfortable with any attorney that you work with, because they're going to be making really tough decisions with you and other things. I'm not a huge fan of hourly fees myself. It's a disincentive in many cases with this type of work of being efficient. And again, I think it's easier for you to know what you're getting into instead of writing a blank check. Just say, I think you should do this, and this is what it'll cost. And you say, sounds good, let's do it. And then again, if you're using a trust, make sure they help with funding a trust. Again, when I started this over a decade ago, our firm at the time and any firms that I'd heard about would draft this great and wonderful trust and then say, now go to your bank and do this, or open up an account at your financial advisor and do that, and leave you with a list of instructions, and then never talk to you again, and you would never call and talk to them again. And then we wouldn't find out until it was too late that nothing was ever moved into the trust. And you spent thousands of dollars to create this great document that was never funded with any assets. So make sure whoever you work with, and you've chosen, I want this account to go here, I want this account to go here, I'm going to open up a new account here, and I'm going to move money from this account there. That's called funding your estate plan. And make sure whoever you work with would help you with that step, because without it, everything you're doing before that is worthless. I'm a visual person, so just so people know, hey, Paul, what if we wanted to talk to you? What would we do? The first step is learning. We do a webinar for basic estate planning stuff that's available on our website, but we also are going to have another one next week here for our group here. But then we can do a virtual consultation if people still aren't comfortable coming in person, or we could do it in person. It's usually 60 to 90 minutes. We would figure out what your personal and family situation is, create a plan for you, and say, here's what you should do, here's what it'll cost. And you can say, sounds good, let's do it, or no thanks, and that's okay too. If we're working together, the next step I would do is kind of gather some information about your assets and the funding so I can put together a plan for you. That's when you'd get your statements together, and we'd figure out what's going where and what should the beneficiary change on this? Should I do spouse first, then trust? Should I do my trust directly? Should I do my child first? How should I do this? And then we do what's called a risk assessment and asset alignment review. So the top right is how long that meeting is. And then again, any of these can be in person or virtual. Even the signing right now could be virtual. We prefer to do them in our office in person, but Missouri is under executive order right now, state of emergency, which allows us to actually witness and notarize virtually. Again, it's set to end actually the end of March. So I think it's going to get extended, but it hasn't yet. So that might be a lie. You got to be in person. And then lifetime communications and updates. So with all of that having been said, I want to wrap up with these couple of things. Knowledge isn't enough. So, it's a good first. Sometimes you leave with more questions, but taking a plan of action is smart. And as a friend of this group, we've decided to offer a discount on anything. If we did wind up helping, we would give a 25% discount. And I wish I could tell you a discount of what, because I don't know what would be appropriate for you, but I can tell you whatever the amount is that we would charge, you would get a quarter of it off, as long as it's in Missouri and Illinois, and I'd be the one that could do it. March 29th, next week at 6 p.m., I want to discuss a little bit more about drafting estate planning, particularly even when your child is young. I know it sounds like a lot of the people on this call have adult children, but anything we're going to talk about, no matter how old the people you care about are, but particularly when it's families of young children and getting at least some basic documents in place, disability planning, special considerations, neat things you can do other than keeping your government benefits or qualifying for the most that you can. So if you have any other things, this is my email address, my phone number. Again, if you want to set an appointment, I would just do that directly with Pat, who will answer our phone at the office and get on the calendar for a time that works for you or you and your spouse. If you have a quick follow-up question about something we talked about today, shoot me an email is probably the best way. Thank you, everybody.
Thank you so much, Paul. We really, really appreciate it.